Now, we'll turn the call over to your host today, Michelle Scrady. Michelle, please go ahead.
Thank you, Kirk, and welcome and thank you all for being with us today. It looks like we have a good group and a number of employers representing Minnesota, Wisconsin, Iowa, Nebraska, and South Dakota. My name is Michelle Scrady, and I'll be standing in today for Joe Ryan. I am a claims specialist, and I've been handling claims for just over 16 years. I'd also like to introduce Beth Giebel. She is an in-house attorney with our law firm, Lynn Scharfenberg & Associates. She has 22 years of experience defending policyholders against workers' compensation claims. Beth is here to answer your legal questions and to give you tips and legal advice on protecting your organizations from workers' comp and related employment lawsuits.
Thanks, Michelle. I'm really glad to be here.
I am too. I'm glad you're here with me. The information that we'll be discussing today is taken directly from your SFM Employer Kit. It's your guide to doing business with SFM and getting claims off to a good start. You can follow along in your Employer Kit, pages 8 through 15. For the most current state-specific information, you can go to SFM's online Employer Kit at sfmic.com. Feel free to type a question in the question box to the right at any point throughout the presentation. Your questions will be answered throughout the hour, and we'll also have a 10-minute question and answer session at the end of the program. The recording of this webcast will be available on our website later this week, and all of you in attendance will receive an email with a link to that recording. So Beth, why don't we jump right into things? First, we're going to run through the 2 reasons why return to work is important for your organization. You know, basically, it is returning employees to work following a work injury is not only the right thing to do, but it is also a good business decision. A good return to work program keeps workers' compensation costs down. It avoids overtime, hiring and retraining costs, and helps an injured employee heal while staying productive, and lessens the likelihood of litigation, amongst other things. Right, Beth?
That's right. That is key.
All right. Well, studies continually show that the longer an employee is off work, the less likely he or she is ever to return to work. Also, most employers have a legal obligation under the Americans with Disabilities Law to return employees to work. Beth will talk about more about that later. The second reason why return to work is important is because it can have a great impact on your organization's bottom line. And this is how. Your organization's EMOD, which is short for Experience Modifier, is an indicator of your claims costs. Now we're going to take one of those quick polls to see how many of you know what an EMOD is. Simply click yes, no, or not sure in the poll that will pop up on your screen in the next few seconds. And while we're waiting for the poll results to come in, I'm going to talk a little more about what an EMOD is and how it can impact your organization's bottom line. An EMOD is used by insurance companies as a multiplier in calculating your workers' comp premium. Almost all businesses have an EMOD, and the industry average is 1.0. If it falls below 1.0, your organization is doing pretty well, and that is going to be reflected in your workers' comp premium. If, however, your organization's EMOD is above 1.0, that means your premium will most likely be higher since your organization's claim costs are higher than the average for your industry.
Now, be sure to hit submit, folks, because I'm interested to know the answer to this.
Well, it looks like many of you may be unsure what an EMOD is. But basically, we want you to know the real kicker is that EMOD stays with your business for 3 years. So if you've had an exceptionally bad year with claims, you'll be paying increased premiums for 3 years. Just think of it, if you get 3 speeding tickets in a year, that's definitely going to affect your auto insurance. So you want to watch the same thing with workers' comp claims. And the biggest driver of your organization's EMOD is its lost time claims. And that is because we have to pay state-mandated wage loss benefits, and those can add up very quickly. And EMOD rules grant a special 70% discount for claims that do not involve workers' comp wage loss benefits. That means by returning an employee to work within the state-prescribed waiting period, you can take advantage of this discount. And it will have more favorable impact on your EMOD and consequently on your workers' comp premium. So now you're probably wondering, well, what the heck is a waiting period? Why is that important? Those are valid questions, especially since these terms can be very cryptic and confusing. The so-called waiting period is a specific number of days that need to pass before an injured employee is eligible to receive workers' comp wage loss benefits. This is your window of opportunity to get the injured worker back to work before those wage loss benefits kick in. we're hoping that one of the biggest things you can take away today is understanding that waiting period and knowing how to use it. And the number of days in the waiting period is different in each state. Why don't we look at all of yours? Here's a chart that shows the number of days in each state's waiting period. Iowa, for example, has only a 3-day waiting period. That means you have only 3 days to get that injured worker back to work before a claim becomes lost time, and we have to pay out wage benefits. In Nebraska, however, the waiting period it's more 7 days. So Nebraska employers have a 7-day window to get an employee back to work before it becomes a lost time claim.
Oh, and Michelle, it should also be noted here that a day can be defined differently in each state. In Minnesota, for example, a day is defined by the Minnesota Workers' Compensation Statute as a full or partial day an employee misses work because of a work injury. In Wisconsin, though, a day is defined actually as a calendar day, which includes Saturdays but excludes Sundays, except when the employee is actually scheduled to work on Sundays. So I know it's confusing, but it means different. The day is defined differently for each state. So if an employee working for a Minnesota employer is injured, let's say at 9 a.m., leaves to get medical treatment, and the doctor takes the employee off work for the rest of the day, that's actually considered the first day of the waiting period since it was a partial day missed from work. Ultimately, what's important for all of you in this is to recognize what constitutes an actual day of lost time because it starts the clock ticking in your window of opportunity. And those days, whether 3 or 7, depending on which state you do business in, are your real opportunity to have the greatest impact on the cost of a claim.
Well, Beth, we have a question here from Cindy. She asks, is the waiting period a time frame that I need to wait before I should report the injury to SFM or a time frame before the employee can come back to work? That's a good question, Cindy. Thanks. We're often asked these questions by employers. The waiting period concept can be difficult to understand. To answer your first question, no, the waiting period is not a time frame to wait before reporting the injury to SFM. You should report any injury to SFM right away. Also, the waiting period is not the amount of time that an employee has to wait to come back to work. Rather, the waiting period is the time in which you have to return the employee back to work before those state-mandated wage loss benefits kick in. Wage loss benefits are expensive, especially overtime, so it's less costly to your organization to get that employee back to work within the waiting period. And if you need more information about the waiting period in your state, please see the Return to Work section of SFM's online employer kit or speak directly with your claim rep to understand how that waiting period applies to a specific case for you all. Well, now we'll look at how early return to work can save an employer money versus bringing an injured worker back once he is fully recovered at 3 months. In this scenario, we'll use an auto mechanic at a Minnesota car dealership who suffered a back injury while he was lifting a tire for placement on an SUV at work. The injured worker is a long-term employee and a high wage earner. His average weekly wage, let's say, is about $1,000. So his temporary total disability, we call it TTD. We are the world of acronyms in work comp. Weekly compensation rate is about $666.67. TTD is payable when the injured worker is off completely. We'll say medical costs for this injury total around $10,000. So if the employer returned the employee to work within the waiting period and within restrictions, wage loss benefits would not be due to that employee. If the employer brought the injured employee back to work full-time in a light-duty job, let's say for 4 weeks at a lower wage, maybe $600 a week, we would owe temporary partial disability, or TPD, for about 4 weeks. So we'd owe about just over $1,000, and the medical cost would stay about the same. If, however, the employer could not find light-duty work for the employee, TTD wage loss benefits owed to the employee for just the 4 weeks are over $2,600 and just over $8,000 if they're off for 3 months. As you guys can see, the medical costs for this non-surgical back injury increased slightly as time went on, but the cost of wage loss benefits, they significantly increase. Not to mention the employees at home not being productive. I always say that's when all the attorney commercials are on during the daytime too. But this example illustrates how bringing an injured employee back to work, even at a lower wage job, can significantly impact your bottom line. The increase in cost may also affect your EMOD factor as well as your premium. For more information about EMODs, please see SFM's eMods Comp Talk or speak directly with your agent. We'll take a quick look at that piece so you can see what it looks like.
Okay, and Michelle, before we go on, there's a really good question from Dan. If you pay them in full for the date of injury, will the waiting period start the next day? Do you want to respond to that, Michelle? I would say from a lawyer's perspective, it does.
It does.
Because they've worked a full day, and
Yes.
then the waiting period would technically start the next day.
It would.
And there's also a really good question about, please explain the right that an employee has to refuse work. And we'll discuss what constitutes an unreasonable refusal of work in just a short time here. So we'll address that as we go on. We'll get right back to that question.
All right. Well, Beth, now that we've looked at why return to work is important, let's take a look at how to get an employee back to work, especially within the waiting period. I know this is probably sometimes the toughest thing for most employers, finding out if it's medically appropriate to do so as well. Being proactive makes all the difference, especially in states where the waiting period is only those 3 short days. So you guys might wonder, what is transitional work or light duty work, however you want to call it. It is temporary in nature, and it is within the employee's physician-imposed restrictions. Ultimately, it keeps the employee in the working mindset, which is statistically shown to reduce time in recovering from an injury. Many of you may not realize what transitional jobs can be. As earlier, they can be part-time or reduced hours. Medical restrictions might limit that employee from working full-time, but you can get the employee back to work part-time. Although there are some wage loss benefits paid to them because of the part-time status, again, it's less than if the employee weren't working at all. In addition, you're providing that employee, again, in that working mindset. I can't stress that enough. The transitional job can also be at a lower wage, if necessary. If you bring that employee back to work in a different position that typically earns a lesser wage, it is okay to pay the employee a lower wage. Some wage loss benefits will be paid to the employee again, even as if they were working part-time, to make up the difference, but overall, again, the cost is less and you're keeping them in that working mindset. If you have questions with that, you can feel free to contact your claim rep and discuss that, and they can walk through the options to see what's going to suit you guys best. Transitional jobs can also be in a different department or location. If you're having difficulty finding transitional work, consider moving them. This might be the only way, to get some employees back to work.
Yeah, that's right, Michelle. A couple caveats with this, though, and this is the perfect time to address the question about the rights that the employee may have to refuse work. The court essentially requires that the work be suitable. In many states, and that means physically suitable and financially suitable. Physically means, again, within the doctor's imposed restrictions, and financially suitable, in Minnesota particularly, that it be 50% or greater of the employee's pre-injury wage. In many states, the employee can decline the transitional job and not risk forfeiture of benefits, wage loss benefits, if the other location that you're offering is more than 50 miles away from the original location. So there's a geographic issue. If the job being offered is outside that 50-mile radius, a refusal of that job may be deemed to be a reasonable refusal. Also, just be mindful of child care or dependency care issues that might rightfully preclude the employee from being able to accept that transitional job offer. So in other words, if they had to care for an aging parent and they had that obligation before during standard day hours, then it would be deemed to be a reasonable refusal of that job if you offered it during those daytime hours. So just look for ways to modify the employee's workstation or existing job to fit within the employee's medical restrictions. And remember that the job does not have to be the exact same job that they enjoyed at the time they were injured. So if you find light-duty jobs such as filing, painting, other jobs on the at the work site, that's completely acceptable as long as it complies with their restrictions. So it could be these modifications could be really as simple as having the employee sit while performing his or her job, moving equipment so the employee doesn't have to bend, twist, or turn to access it. Ultimately, you just need to choose a transitional job that fits really within the employee's medical restrictions. That's the most important.
Absolutely. And the first step is being proactive with transitional work. Part of an organization's return to work program should be identifying transitional jobs and duties that employees can do while they're recuperating from their injuries. Identifying these duties before an injury occurs saves valuable time during that waiting period. For many organizations, especially smaller ones, developing transitional or light duty jobs, it can definitely be challenging. Ultimately, you want that employee to recuperate and still work, so you need to be creative. Seasonal jobs that don't get done during the busy season or can only be done during the summer or winter. If any of you are like myself, at home in the fall, you don't get to things that should be done in the springtime. We all have a million things we need to do and never enough time. So putting those in writing at your place of business is just a smart thing to keep track of. Tap into your employees and your supervisors. They're the ones out there every day. They probably know the things they can't get done during their regular work day, but that need to be done. And you're also encouraging them and including them in those ideas. And you want to think company-wide, not just within the department the employee works in. Many things people can do. Talk to your SFM claims and your loss prevention representatives. They work with employers across all industries and are definitely a good resource for you. And when reviewing job descriptions, consider ways in which the job can be modified in the event that an employee is injured. For instance, can only work one-handed or lift 10 pounds. Sometimes the jobs will be permanent, so we always need to think ahead too at times depending on the injury. Use SFM's transitional warehouse at sfmic.com. It includes more than 600 light-duty jobs across 7 industries. And I know when I go out to my employers, Beth, I always encourage them to look across all of those industries because things that you might not think at a clinic might affect you in a manufacturing. It all kind of relates, and there's just some different ideas that might spur more ideas if necessary.
Yeah, it's such a good tip, Michelle. And I just tell my policyholder clients, give as much thought to it in advance that you can, because then your employee base, your workforce know that you're committed to light-duty accommodation. You communicate that through your supervisor leadership, and it just helps overall in communicating that you are committed to helping them successfully return back to work with them.
Oh, absolutely. And, keeping that updated list of transitional light-duty modified jobs, it'll just be that much quicker when an injury does occur. I always remember one employer who did filing, which is a general light-duty transitional work. This employer took out the same paperwork for every day for 2 weeks. I don't know what that says about the employee necessarily, but the guy refiled that paperwork for 2 weeks. It kept it a medical-only claim. So that is all that mattered to us at the time. Using the comment question box to your right, tell us what transitional jobs have worked for you guys in returning injured employees to work. We're going to read them as they come in, and maybe your suggestions will spark ideas among our participants here today.
And while they're doing that too, Michelle, we have a very good question from Gail. If we offer a light-duty position on a different shift and they refuse based on child care difficulty, is this considered a refusal that's acceptable? And the answer to that first part of the question is yes. If they had a pre-existing child care obligation during a particular shift, then it really, I tell my clients it's really off limits. It can't be an obligation they take, a child care obligation that they take commensurate with the job offer. It has to exist before the job offer is made. And the second part of her question is, do we need to then change their shift to accommodate that? And my recommendation to my policyholder clients is I would recommend, yes, that there be a shift change to accommodate that child care consideration. That ensures that the job offer, if refused, will ultimately be deemed to be a suitable offer that was unreasonably refused. And then there are implications for work comp benefits.
Well, I can see that there's filing and shoveling and answering phones listed as light-duty best. So there's a million of them out there. So I encourage you guys, again, to keep your lists and keep them going. SFM has a sample temporary job offer available in its resource catalog to help you guys craft one for you. And it can be found in the SFM resource catalog. It is available to be downloaded as a Word document, so you can simply modify the text to meet your needs. It's a really good resource. Well, this is one of my things I always try to encourage my employers with. The second step in creating the Return to Work program is to really educate, train your supervisors. Most of you guys out there today are our contacts and the ones that we get our information from. But it's your supervisors and leads that are actually out there interacting with the injured worker on a daily basis for the most part. And they should really be aware that your organization has an active return to work policy that includes offering temporary transitional work to injured workers. I know myself and a fellow coworker of mine recently heard from a policyholder on a return to work issue. The organization's claims coordinator, the person who reports to us, was on vacation. An employee was injured, went to the doctor for treatment, really placed on relatively minor work restrictions. The supervisor told the employee to go home and not come back until he was fully recovered and off of his restrictions. Well, clearly the supervisors in this organization, and maybe particularly this one, weren't trained on what they should do when an injury occurs. By having that employee stay off work until he recovered, that claim, as you can imagine, way more expensive because we had to pay wage loss benefits for 3 weeks. In this situation, the supervisor should have made his best effort to accommodate any medical restrictions to keep that employee working. It's also important to train your supervisors how to report an injury, what their role is, and how their decisions are going to impact your organization's bottom line. They're also an important resource in the return to work process. You're going to need to ensure that the supervisor knows what the employee's restrictions are and ensure that the supervisor doesn't have the employee work outside of them. I know it can be construed as babysitting at times, and it might be in some cases, but it is important for them to do that. During the recuperating process, you want the employee to remain productive and not to risk re-injury. That's why it's important to communicate with your supervisors to ensure that they know what the restrictions are and that, again, that the employee isn't working outside of them. And you should be getting regular updates from the supervisor, including whether or not that employee is working within his restrictions.
Yeah, good point, Michelle. And this is a good time just to take this quick question from Tom. If an employer pays transitional employee a lower wage during the return to work period, will work comp cover the difference in the wage disparity? And the answer to that, Tom, is yes. That benefit is called temporary partial disability benefits, and it's the difference between the pre-injury wage and the new wage that the employer is paying, and then two-thirds that. So yes, workers' compensation benefit, the work comp benefit does cover the difference.
Thanks, Beth. And for more on the supervisor responsibilities, you can see the Comp Talk from SFM's resource catalog, and you can also download that. And the third step in staying in contact with the injured employee. This is key. Lack of communication is the #1 cause of injured employees seeking legal help. One of the best plaintiff attorneys in Minnesota said his business would be cut in half if the injured employee supervisor just called or visited within 24 to 48 hours of an injury. Just a simple conversation about how valuable that employee is and that he or she should concentrate on getting well makes a huge, huge difference. It's all it takes, in many cases, to prevent the sense of abandonment an employee may feel after an injury, which is what usually drives them to attorneys. The couple minutes it takes to make that phone call or visit are very meaningful to the injured worker and likely to make a huge difference in the claim. Wouldn't you agree, Beth?
No question, Michelle. I mean, as you can imagine, the cost of the claim can immediately skyrocket once an attorney is involved.
Oh, and that is so true. Well, again, to recap, have those supervisors or someone at your organization call or visit right away that injured worker. And you want to make sure you answer their questions about benefits, insurance, and other questions. He or she might be scared about what the injury means to their job and their ability to make a living. Most injured employees are unsure of workers' comp, so you want to try and put their mind at ease. You want to explain your expectations that the employee returns to work in that transitional job. Explain about the job and what your expectations are of the employee. They're still your employee, and you need to treat them as such. Let the employee know that you'll be in contact with his or her doctor, and let them know that you're going to tell that doctor that you guys have a return work program and offer transitional work. And you remind the employee to work within their restrictions, and that you'll remind their supervisors, so everybody's on the same page.
Yeah, it's so important, Michelle. I tell my clients that just ensure that the employee knows that he or she should bring you a copy of the report of workability after each doctor's visit. This is really important and just assists you overall in exploring, reasonable accommodation after the injury.
Exactly. Well, we go back to that communicating with the treating doctor, and we're going to look at the report of workability later. But why don't we take another quick poll? How many of you have an existing relationship with a clinic or a doctor that specializes in occupational medicine? Just a quick yes or no answer is good. Establishing a relationship with a clinic or physician that specializes in occupational medicine, it's going to help get employees back to work within the waiting period. They know you, they know your organization, they know the kind of jobs your employees perform. So therefore, when an injury does occur, you're going to be prepared to quickly respond, and so will they, to get that injured worker back to work. In many states, the employee ultimately has the right to choose where to treat. However, I always tell my employers, there's power of suggestion. I know we have forms that you can put up in your facility that indicate if you get hurt, this is where we go. You have the right to suggest that, and a lot of times it works, and it helps us keep a better, handle on the claim. And for more information on how to establish that relationship with an occupational medicine provider or to find one, you can see SFM's Responding to Work Injuries webcast on sfmic.com, or again, just talk with your SFM claims rep. Well, it looks, I think a fair amount of you have established relationships with a clinic. That's awesome.
It's good to see, Michelle, because I'll tell you that's the easiest and quickest way to get a good jump start on exploring accommodation for injured workers. So it's good to see.
Oh, it is, because not only do they understand the work and the return to work, but they also kind of understand the system at times, whereas personal MDs just don't seem to have that concept. So, you want to stay in contact with the treating doctor while the employee is recovering from an injury. It's very important. You're going to need to discuss the employee's physical capabilities because it's crucial for you to know what your employee can and cannot do. The return to work status, the date of the employee's next appointment, and any questions that you have about the workability form. You can send that physician a transitional work letter. SFM has sample letters for you to use in its resource catalog. The letter should explain that your organization provides light-duty work and has a transitional job for the employee. Ultimately, the goal is to, again, get that employee back to work. Most employers, they'll call SFM saying, the physician or the clinic won't talk to them because of HIPAA, medical privacy issues. But state laws allow employers to have access to injured employees' medical records so that they can see the work restrictions. Isn't that right?
That's right. I mean, we live in an age where everyone is terrified, Michelle, of being sued, and especially doctors, unfortunately. So even though employers have a right to see this information with a few restrictions, many clinics are still very reluctant to give any information out. In these situations, it may just be best to contact, again, your SFM claims rep who will give the clinic a call. I mean, for the most part, HIPAA privacy rules don't apply to work comp claims. Some provisions apply, but only to the work comp insurance company or the self-insured employer, so not the general employer. So the general guideline for my clients on handling work comp is that you have a right to discuss an injured employee's progress and existing medical history with the physician as it relates to the work injury. With supervisors, I always recommend just focus on jobs or tasks that the employee can perform instead of actually listing the restrictions to avoid any violation of medical privacy issues. See your state-specific rules on HIPAA and medical privacy in SFM's online employer kit. That's a great resource. There may be times when it's difficult to reach a doctor directly in those cases. Just contact your SFM's claim rep, and they can help you. And Susan, I see that you've asked, even if you have a relationship with a clinic, the employee does not necessarily have to go to the clinic of our choosing, correct? And Michelle was right on. You cannot. They're not required to go to the clinic that you recommend that they go to. They have a choice. But in my experience, employees will come to your office and they want some guidance as to who they might go to see about their injury.
Again, the power of suggestion. You guys do have some roles there. Just if they ask where you're injured, you just tell them, and a lot of times they'll do it. It's innocent, and it can steer them in the correct location for us. So it'll just give us a better handle here at SFM on the claim if we can get them into a provider that we know can work with work comp. So. And, we're going to talk a few minutes about that all-important workability form. Some doctors or clinics, they have their own form. They can be called different things, a job slip, medical restrictions form. And regardless of what it's called, you cannot bring your injured worker back to work without some form of a medical release. In some states like Iowa, doctors might be more inclined to provide a doctor's note or release versus a complete workability form. In any event, you want to be sure to get a document signed by the doctor after each of the employee's doctor visits. This form essentially informs you of the approved functions that the employee can perform based on the medical evaluation. The last thing you want to have is that employee re-injure or exacerbate the injury because he was working outside of his restrictions. If you or the employee feels that the employee can perform more than what the physician noted on the form, contact your claim rep. He or she can contact that physician and see whether modifications can be made. A lot of time in the world we live in, I have probably 3 right now who really want to work overtime, trying to get the restrictions, limit or lessened so they can work more. It does happen. So this is a sample workability form that SFM has created, and we encourage you to download it from SFM's website. And I encourage all of my employers, give it to that injured worker. If you know they're going into the clinic, give them a copy of this. Let the doctors fill this out because it is pretty concise and it's clear for us.
It's very helpful in giving my clients guidance. Instead of the standard forms, work as tolerated, work a few hours as necessary. This gives specific guidance to my clients. And this is a good time actually to take Nancy's question. Does an employee who does not stick to their restrictions risk losing their work comp benefits? Nancy, this is a question I often get from my clients. And it doesn't necessarily have an implication or doesn't have an adverse effect on their receipt of benefits, but I do say that it is a performance management issue. I always recommend my clients meet with the injured worker, talk about their expectations and their commitment to staying within the employee's restrictions. And then if they fail to do that, issue a soft warning at the beginning that they need to comply with the doctor's restrictions for a safe work experience. So it really goes to safety for them, and then they just need to be progressively managed from a discipline standpoint if they fail to abide by those guidelines. But it does not have a direct implication on their ability to collect workers' compensation benefits.
Thank you, Beth. I don't get that question a lot. That workability report, there are things to watch for. Beth mentioned a couple of them. If you get them back indicating they're not able to work, no use of the injured body part, we get a lot of no use of that right hand, working as tolerated, or it lists a million significant restrictions that just seem absolutely impossible, or if they're just that far out, maybe a month out at a time, those are the things you want to watch for and definitely should alarm you. These kind of restrictions slow the process and delay the employee's return to work. You do see it more often from physicians that don't specialize in occupational medicine. That's why we encourage you to try and get that relationship established. Again, most important, you should receive that updated workability form after each and every visit. If the employee doesn't give you one, which he rightfully should, then you want to contact the physician yourself, and you can do that, or you contact your SFM claims rep, and they will get it for you.
And I'll take this one, Michelle. The sixth point is how to legally protect your organization. There are some tips to protect your organization that we can address here. And some of those include, just put the temporary transitional job offer in writing. I have to say it's one of the most important actions you can take to protect your organization. I take that written job offer letter in with me as an exhibit in trial, and then there's no mystery as to what my client has offered or what the employee has unreasonably refused. So it's a good exhibit that reduces to writing the date of the offer, the details of the offer, and what restrictions it was complying with. Document everything. That means keeping copies of all workers' compensation correspondence, report of workabilities, document conversations that you've had with the employee and the supervisor about, your collective commitment to working within their restrictions. Document the time the employee's working, whether the employee's called into work, the results of each doctor's visit. document changes or upgrades and restrictions, or any questions that might be have been expressed by the employee. It's important to note that these workers' compensation documents, though, should be kept in a different file than the employee's personnel records.
And Beth, can you say why that is?
Well, personnel records are discoverable in workers' compensation cases, so my clients will be routinely asked to disclose the contents of the personnel file. But I may have, in fact, some privileged communication or documents exchanged between my client that ought to be kept separately in a confidential work comp file, and that is not discoverable. So in all cases, I would oppose the disclosure of any of the contents of a work comp file containing privileged information. So, a work comp injury is generally covered as a disability under the ADA, which means that the employers have an obligation under the ADA within reasonable accommodations to return employees to work, or frankly, they may be at risk of an ADA lawsuit. So you're really taking care of both obligations, both from a federal standpoint and your own state's guidelines in offering work.
Thank you, Beth. Well, we have collected the top 5 frequently asked questions by employers and collected our top 5 tips and best practices to share. And we're hopeful that you guys can incorporate some of these into your organization. To kick off the top 5 frequently asked questions by employers regarding return to work issues, I've heard this a lot. What if I'd rather fire a problem employee? Is that okay? Ideally, when a workers' compensation claim arises, it is not the time to deal with a problem employee or one who has had performance issues in the past. However, we typically see employers doing just that, using a work comp claim as ammunition to fire that employee or antagonize a situation. Terminating a problem employee who is receiving work comp benefits is very costly. Just like a long-term absence, your action could drive up the cost of a claim. Before doing something that you would later regret, you want to make sure you consult with your claims representative or one of our attorneys. Find out how much that impact will be on your EMOD and premium. You're also risking an expensive lawsuit for retaliatory discharge. Wouldn't you agree, Beth?
Oh, no question, Michelle. Firing an employee can significantly increase the cost of a claim. These are clearly difficult situations, but they're often best resolved by at least bringing the problem employee back to work and then dealing with the performance issues, or at least making him or her a job offer for transitional work. Ultimately, it needs to be a good business decision for you. But if an employee is let go at a time shortly after a work injury has occurred, I tell my clients there is per se exposure there for retaliatory discharge or some other EEOC claim potentially for a discriminatory practice. So it's not the time to deal with performance issues.
That is so true. Second question. If I already filed a claim and the employee starts losing time from work, what do I do? Well, if you've already filed the claim and it's filed as a medical-only claim, you want to contact your SFM claims representative. Let him or her know that the employee is now losing time from work. This step is very important. Claim reps have 14 days to pay or deny wage loss benefits per the state to avoid any kind of penalties that could arise, and we have to get those wage loss benefits out. So make sure you contact your SFM claim rep again if that file was assigned as a medical only and they start losing time from work. The third question, what do I do if the treating physician clears an employee to work, but that employee claims that he or she cannot work? Honestly, to me, Beth, they're forfeiting any kind of benefits. If they're risking that they're not going to work any light duty, they're forfeiting their opportunity to get paid either way by us or by the employer if they're refusing it.
That's correct, Michelle. There's no clear direction about an employee's ability to do the job than their own physician imposed guidance. And so an unreasonable refusal under these circumstances will likely result in a permanent forfeiture of benefits. So there are serious consequences, particularly in Minnesota, for unreasonably refusing work that your physician clearly has opined that you're capable of doing. Well, let's look at that fourth question, too. Should I not let the employee return to work without a report of workability? I think if it can be easily obtained by just simply instructing the employee to take the report of workability in and return back with some guidance, I think that's a better practice. If you have some guidance in terms of restrictions, Michelle, and they were imposed the week before, and it doesn't look like the doctor is going to be changing it anytime soon, then I'm less concerned about that, frankly, for my clients. But if my clients don't have any guidance whatsoever in terms of restrictions, then I'm more concerned about the employee being on the work site.
Or if there are those restrictions that are extremely, the no use of right hand, very significant restrictions. If they jump from that to nothing, I think you should always try to cover yourself as much as you're able to.
Yeah, and I think you can always ask for clarification from a doctor. If you've got work and you believe that that it might be physically suitable work for them.
Absolutely.
Talk to your claim rep and have them clarify.
Absolutely. Well, the fifth question: how do I stay up to speed on a claim? Comp Online is SFM's online resource where you can stay up to speed on claims. It's free for SFM policyholders. Although because it contains sensitive medical information, you're going to need to register for a password. You can see what's been paid on a claim, what the reserves are, and who your SFM contacts are, among other things. It's a great tool. I recommend you guys take advantage of it. You can also contact your claims rep at any time for this information as well. Well, now we'll start out with our top 5 tips and best practices. Beth, why don't you take the first one?
All right, will do, Michelle. Offer light-duty work. I think we've reinforced that message considerably through this presentation, but simply put, offer the job. It really is a tremendous help to all policyholders to explore light-duty accommodation. Even if you don't have all the details worked out yet, offer the job to the employee and then call your SFM claims rep to further discuss. Review your organization's return-to-work policies and procedures and keep them up to date. We're in a time right now where, I think the labor market is recovering and there's the job market is showing some growth. Take this opportunity, frankly, to review what you have available and review your internal policies and revise them to expand your light-duty job offerings.
And second, regularly review transitional jobs. Add as necessary. Because of this information and the technology revolutions, many jobs and duties change. Ensure your lists reflect this.
Yeah, good tip.
Third, you want to be sure to fax that completed workability form to your claim rep after each of the employee's doctor's visits. It's really your best way to keep that claim rep in the loop. And if you don't necessarily spot maybe a red flag or anything, the claim rep might and be able to get on that right away.
And I'll take this one, Michelle. Notify your claim rep if you notice any red flags with the employee at any time during the course of the claim. Red flags might be that the employee is dissatisfied with the temporary job, or he or she is doctor shopping to stay off of work. There might be continued complaints of constant pain, missed doctor's appointments. If you notice any of these red flags, let your claim rep know. That's when they get the attorney involved, and they can help manage some of the absenteeism issues that are taking place.
Absolutely, very important to keep your claim rep in the loop at all times. Use your SFM resources. Workers' compensation is our only line of insurance, and we are specialists in it. You don't want to be afraid to contact claim rep, your loss prevention rep, one of our nurses, attorneys, anybody here. We are all here to help. So please check out all the information and resources again on our website. We have a great communications department that keeps us up to date and helps us do our jobs better with you guys. We literally have over 400 pieces to help educate, a video lending library, kind of like Netflix, online employee training modules, and online services, because we want to help you make your job easier. So please go to sfmic.com and just click the Employers tab.
Yeah, it is a really good resource, Michelle, and there are also legal updates that are oftentimes posted that will address more contemporary issues.
They're very helpful.
All different ADA and FMLA, and we're involved in updating those routinely too, and that will help coordinate an employer's return to work effort, both on the federal level and the state level. So I encourage my clients to look there too.
Yeah, really, it's just an awesome resource for you guys to view and check out. Well, that is our program for today. We have about 10 minutes left for our Q&A session. But before that, on the screen, you're going to see our contact information. And feel free to contact us at any time in the future with your questions. Again, we're happy and we're here to help you. So be sure also to complete the evaluation form. That'll appear once you exit the webinar, and we thank you for that. So now why don't we get started if there's any questions out there that we can help you answer. And feel free to type those questions in that Q&A box to the right of your screen. Beth and I are here to answer.
And I'll take that first question from Anita, Michelle. Her question is basically, do I understand you correctly that you might be supporting a plan that an employer pay for the employee to file the same papers every day? Why would that possibly make sense? And Anita, this is what I would tell you. I have policyholders that that do the best they can in terms of finding things that just need to be done at the workplace. My recommendation always is to find meaningful work, because it's important, of course, for it to be a smooth transition, and employees certainly want to feel as though they're contributing. But in some circumstances, to bridge the job that they enjoyed at the time they were injured, bridge that job with some sort of permanent light duty accommodation. Sometimes it's important to do filing, office work, phone work. We certainly don't promote the prolonged use of these types of temporary jobs, but the benefit, Anita, is that once the employee is back to work full-time doing this kind of work and other kinds of work for you, they are establishing an ability to earn at their regular wage rate. And that's very important in the overall management of the claim, that you can argue that they're capable of working full-time at the wage rate they enjoyed at the time that they were injured. And so it has significant implications in terms of the long-term exposure of a work comp claim.
Oh, absolutely. And this claim, like many other claims, has a bigger story behind it. And the filing was just for a week, but it was a highly suspicious claim, a fraudulent, suspicion in the employer's part. They were a 5-person office. They needed to offer something and just didn't have it. And this helped them out. It kept it a medical-only claim. We got a release to return him to work without restrictions, and then they were able to let him go eventually. But, we had to get creative, and again, I'm not saying what it says. The guy didn't realize he was filing the same stuff every day, but it worked. We all had to think out of the box, and in the potential lawsuit that this could have created by them not offering that and him being off would have affected their bottom line, and they just simply couldn't afford that. So we're willing to try.
Well, and I will also say, in my experience, one of the toughest kind of consequential claims that we saw over the last 3-4 years as the labor market tightened are these consequential depression claims. I will say that being out of work, and these folks support families, that's a very, very tough situation to be completely out of work. So what happens is there's an additional benefit of avoiding some consequential type psychiatric claims that might result from a prolonged disabled or disability from work. So, I saw a spike in psychiatric-related claims in some cases, where they couldn't go back right away.
I always tell people work comp is a system just like anything else. You get welfare and other forms of that, and they're not used to having to be responsible. And within that, and it's confusing, it can be scary, and this is their livelihood and their medical treatment. People want to be cared about, and that's why that communication is so important too. But it can definitely, when they don't feel that they're encouraged, or if they're being made fun of, or feeling, the effects of a coworkers making snide comments about the light duty, that depression is huge, and it will just make a claim go on forever, it seems. What if the employee wants to use vacation time to stay home from work if the doctor says they can work? They can do that. That's a choice. We file forms indicating that they opted to use their own vacation time versus then that light duty was available for them and they declined. It is a forfeiture of wage loss benefits.
So you file, in Minnesota, you file a form called a Notice of Intention to Discontinue Benefits,
yes,
right?
Absolutely.
And then, of course, that really suspends or terminates their eligibility for workers' compensation benefits because their choice of being out of work is voluntary.
It is voluntary. They will have the right to dispute that if they want it, but most don't. If they're taking their time, they just want to get paid, and typically those are the ones we see come back to work right away. So.
And there's a question, Michelle. Does any of the information presented apply to workers who are injured on their own time and not covered under workers' comp? Absolutely. The federal and state laws impose an obligation on employers to treat all injured employees the same way. And so I encourage my clients, of course, to explore accommodation if it doesn't cause any undue burden on their workplaces or their financial situations, that they explore accommodation and start with that interactive process with injured workers. So the same applies essentially for non-work comp injured workers as it does work comp injured workers.
Oh, absolutely.
You explore light duty accommodation the same way you would, and that's essentially an interactive process with the injured worker. And then you have FMLA and ADA considerations, but that we'll present it on a topic like that sometime, perhaps this summer or next year.
All right. Yeah, because they all do kind of intertwine there.
They definitely do. Now there's a question here that I can take too. We have some time remaining. Can you share an employee's restrictions with their coworkers if they share work? For example, 2 employees providing care for a disabled adult. Really good question, Tricia. Actually, my recommendation would be the same as it would be in dealing with restrictions with a supervisor. My recommendation would be with a coworker is to only share job tasks or duties that an injured employee can perform. So I would say I always recommend stay away from the specific restrictions and the medical reason behind that restriction, and then you never risk violating any sort of medical privacy issue. I think you can have you can sit an employee and a coworker down and simply talk about what the injured worker can do with, say, a disabled adult, a job-related task, without ever really talking about the specifics. And so my recommendation in answer to your question, Tricia, would be I would recommend you not share the specific restrictions with their coworkers. And it looks like we have just a few more minutes. We have some time to take another question. And this is a question that addresses what an employer can do in terms of light-duty accommodation. The question is the employer allowed to have an employee do things around their private home? And the answer to that is yes. I do have some clients ask me this.
Yeah, I've had them do that as well.
Yeah, I always say that, be careful. I guess the one word of caution I would have is if it involves a long drive. There may be some additional liability considerations if they're on the road, and they may not be medically restricted from driving, but they may be taking medication. Because of course, if they're injured en route to your home to perform additional work, then that accident is covered too. That's another work comp injury. So yes, you can, but there are. I always just tell my clients to be aware of some additional liability considerations.
Oh, absolutely. Even slipping and falling on their property could be
That's right.
a new injury. So you want to just make sure it's what you need help with, and if it's a last cause, I think sometimes maybe I would encourage that myself.
Yeah, I always say the best recommendation is first and foremost to find suitable work at their original location. That's really the best practice.
All right.
And I think that wraps up the available time we have. I do note that we may have just a couple of questions left, but we'll make sure to get those answered for you folks.
Absolutely. Well, we all of us here really appreciate your attendance today. And remember that a recording of this webcast will be available on our website early next week, and you're going to receive an email with a link to it. Thank you all so much.
Thank you for joining us.